Um, we welcome you to another press briefing by the Abuja School of Social Political Thought. The Abuja School, on the outcome of the Edo governorship election, the tribunal decision. In the past, the Abuja School has held a press conference and a policy dialogue on the outcome of the Edo governorship election. This continued focus on the Edo governorship election 2024 is not because electoral malpractices only occur in Edo. Electoral malpractices have become a staple of Nigerian politics and occur everywhere. It's also not because Abuja School cares about the end of the candidates in that election. No, we don't actually care about the outcome or who wins or who didn't win. But it's because of its wider implication for survival of democracy in Nigeria. The Abuja School is non-partisan and an independent think tank of scholars, intellectuals, and policy professionals committed to the propagation of insights and ideas that can transform the African society and usher an era of quality livelihood for the people. The Abuja School prides itself with its social science-oriented rigor and courageous leadership on policy formulation and program implementation. Since 2022, in the build-up to the 2023 general elections, the Abuja School has continued to put a searchlight on the activities of the Independent National Electoral Commission, INEC, the body that was responsible for elections, and the activities they conduct and the impact of these activities on the credibility and fairness of elections in Nigeria. After the 2023 election, the Abuja School reviewed INEC's performance, all the issues, and came out with a publication titled Elections Without Democracy. This was the product of our election observatory hub, which is a platform where we brought in experts to observe not just the results of election, but the processes and the way that elections are being conducted and what they mean for democracy in Nigeria. Now, that publication concluded that there are so many errors and deliberate malfeasance by the electoral management body that if we keep ignoring that those bad performances by INEC, Nigeria might move from a democracy to an electoral autocracy. Now, that prediction has now been confirmed by the reputable Verity of Democracy, the world-leading scholarly platform that assesses democracy. Today, they rate Nigerian democracy as electoral autocracy. So you have elections, but those elections are shambolic, and what you have is actually autocracy. That was what Abuja School wanted to prevent by our Deepening Democracy series. Like I said, the school has no interest in who becomes the governor of any state and none about Edo State as well. Our continued attention on Edo State governorship election underlines the stark nature of the electoral malpractices committed in that election by officials and ad hoc staff of the Independent National Electoral Commission, and the implication of those atrocities on the prospects of free and fair election, on democracy and democracy in Nigeria. Now, Edo State election is an important connecting bridge for us between the 2023 general election and the 2027 forthcoming general election. It's a connecting bridge. We want to focus on saying, first, has INEC learned anything from the general election, the failure? Is that going to be improvement because it's off-season? Off-season elections are elections that help you assess whether you see improvement in the human factor, in processes, in machinery, and in technology. Again, it tells us a story about what we could expect in 2027. Now, so end of the day, Abuja School looks at these atrocities in that election as barometers to measure the progress or lack of it in our journey towards credible elections that can overcome the growing tendency towards autocracy and instability in Nigeria. It is noteworthy that Abuja School has remained resolute in the belief that the survival of democracy in Nigeria and then the Nigerian state surviving depends on an electoral process that gives citizens assurance that voting can be a means of changing government. So the idea of democracy is that citizens can change the government, and because they can change government, then it means that incumbents will try to govern well, do their best to serve citizens. Now, where the electoral process can no longer guarantee change of government because that process has been hijacked, then the incentive structure in democracy that makes it perhaps more efficient and more acceptable than autocracy is lost. The real thing about democracy is, like Scott-Peter defined it and said, is that citizens can sack government and they go. If that is out, then the value is gone. So now, with the elections, when we had a press conference and we spoke about the deliberate way INEC manipulated and rigged the 23 election, this is not about APC or PDP, it's about INEC. They didn't do what they ought to do. They printed duplicate result sheets and announced that this has been verified by authoritatively with forensics in South Africa. So what the Abuja school is now expecting that this goes to the court, and therefore the court will take its time to reprimand and nullify everything that has done. Now, the base of judicial involvement in the election is that where the electoral manager truncates, violates the electoral process, the judiciary will reverse as an incentive. You see, everything about governance is around incentive. If the electoral manager goes roguish, as INEC goes from time to time, the redeeming feature is that the courts will knock their head so that they send a message that next time don't do it, it doesn't pay. Because if you do it, the court will knock you kwako, as we say in Nigeria, okay? But where the court legitimizes, validates that atrocity, it further sends a message that next time, do it, it pays. Now, let's get to the issue now about this Edo State matter. We need to break it down. The petition filed against INEC in Edo State goes to two core issues. The first issue concerns non-compliance, specifically under Section 73, Sub 2 of the Electoral Act, which mandates that before the commencement of polls election, INEC must record the serial numbers of all sensitive materials such as beavers, machines, ballot papers, and result sheets. And they record it in the prescribed form. That prescribed form is from EC 25B that INEC is provided. It's in the annexure to the Electoral Act. Now, why is this important? In the past, elections have been rigged because criminal-minded INEC officials and their collaborators would print duplicates of results, give to one of the contestants. So after voting, you enter results. Then at the collection center, they will announce a different result. So to overcome that loophole, the Electoral Act says, before you vote, the real result you use, the real result sheet, and the beavers and all the sensitive materials, you have to first write down the serial numbers so that this agent sign off, so that it's be that number serial number you use. So that's what is required. Now, failure to do this renders the election in that polling unit automatically void. The Supreme Court, in the case of Augustine versus INEC, clarified two crucial points about Section 73(2). First, the Supreme Court says that the prescribed form is from EC 25B, as specified by INEC itself. Second, the Supreme Court said that it's a strict liability provision. What that means in law is that once it is on the face of it determined that it has not happened, no further evidence is required. This means that the petitioner only needs to tender the documentary evidence that the forms were not filled. The idea, now what happened in this case is that the tribunal discounted this argument on the notion that they ought to call the maker of that form to testify. This is nowhere part of that. Or that you are going to bring the polling unit agents in all the polling units must be called to testify. That's the basis on which INEC disallowed this obvious, or not INEC, the tribunal disallowed this obvious point. But the point is that the idea that the maker of the document is the only person who can speak to the form, or that the polling unit witnesses must be called, is a legal fiction with no grounding in Nigerian jurisprudence, especially considering recent reforms in section 137 that says non-compliance renders the process void. The section 137 says of the Electoral Act that no oral evidence is necessary where the documents themselves show non-compliance. So if after election the document shows that you didn't comply, you don't need to call oral evidence. I will say more about why the danger of this burden that some courts are giving to petitioners, all it is. So that's the first leg of the petition, that those documents, the serial number not being written as required by law, renders. And why is this important? The argument here is that duplicates were printed, and the results, the result sheet used to declare winner is different from what's uploaded on the IRM, and therefore they were forgery. Okay. The second leg of the petition that the tribunal disallowed or didn't accept deals with the fraudulent collection of election results. The reason why we have, and some of our Abuja school has always demanded that there should be electronic transfer of results from the polling unit straight to the IRF, is that the crisis point for the election is collection centers, where through violence, criminality, or basically roguery, results are declared. From polling units, it's difficult these days to read elections because the accreditation, the agents will be there, they sign off that result for the polling unit. It's when they now get to the collection center that this magic happens. So this allegation of fraudulent collection of election results is perhaps the most damaging allegation because it highlights a systematic manipulation of results by the umpire itself, INEC. In the election, INEC printed and deployed duplicate result sheets which were used to declare results that bore no resemblance to what actually occurred at the polling unit. This was, of course, established by CAP Initiative. CAP Initiative did extensive work, took the results to a forensic examiner in South Africa, and they confirmed that those were duplicates, they are not the real election sheet. CAP have also petitioned ICPC to investigate and prosecute those found culpable. So this is not imagination, this is real, that duplicate results were printed and used. Now, for example, at the polling unit, APC will score 31 votes. Now, this is the result posted on IRF and it's still there. Then, but in the declared result, certified by INEC, you will see votes recorded for APC around 431. They add 4. Okay. Now, the position of the Supreme Court on this matter is unambiguous. The Supreme Court in the whole Posadema case was very clear that where improper collation is alleged, there's no need to call for polling units agents as witnesses since the conduct of the election is not in dispute. So what the Supreme Court is saying, said in the whole personal case, if you are saying that elections are improperly collected, you don't need to call all the polling unit of the whole polling units agents to testify. But what they do, Election Tribunal did in effect is they rejected these arguments. I read the judgment carefully. They led to, in fact, my Lord Justice Okoro, no, in the previous case of Augustine, my Lord Okoro says, in view of foregoing foregoing, in view of the foregoing, I make bold to say that the language used by the draft man in section 732 of the Electoral Act is clear, and says that it's clear and unambiguous. There is no need going outside the words used in search of an interpretation. And contrary to the submission of learned counsel for the various respondents, the word shall used in that section connotes mandatoriness. It therefore means that where it is established that an election was conducted without prior recording in the form prescribed by INEC of the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive materials deployed for the conduct of that election, as prescribed by section 732, such election in the affected polling unit shall be invalid. It is a strict liability provision, subject, however, to the provision of section 1351 of the Act, which mitigated the avoidance of election on the ground of. So what the Supreme Court says clearly here is that where you establish that those numbers were not entered, you should invalidate the results from those affected polling units. Again, in those other case, the Supreme Court says, if collection is irregular, you don't need to call witnesses. Now, the tribunal made 2 points. First, the tribunal argues that the petitioner should have called polling witnesses or persons who were there when the two were not being entered. On the issue of wrongful collection, says you have to get the agent, people who are there. The point Abuja School is worried about is the growing strategy of courts defeating the essence of the Electoral Act itself. The Electoral Act changes in the Electoral Act is placing burden on INEC, the regulator of elections. The courts are placing burden on victims of electoral malpractices. It's not just about technicalities triumphing over substantive justice, as the Supreme Court have warned. It's about creating opportunity for desperate politicians to undermine the Electoral Act. So in essence, what the court, the tribunal, Edo Tribunal did in effect, is to validate an electoral coup executed by INEC. For example, the tribunal issued a subpoena that they should bring the ballot box, the beavers. And the people who brought it says, we can't operate it. And the tribunal in the judgment says, he can't dump evidence on us. Now look at the problem. A victim of electoral for fraud complains. INEC has the materials to demonstrate. INEC is subpoenaed. INEC brings the beavers. People who brought it say we can't operate it. And the court cannot mandate INEC to come and operate it so we can see. The court now uses and says, you did not operate the beavers. You sent us a postscript, a snapshot, certified result. But the law is, in fact, the tribunal, in my view, misconceived Joseph Okoro's statement when he says that, especially in the case of Adeleke, when he says that to prove it, you show the accreditation, you show the results, you show the beavers. It's INEC who ought to operate the beavers, not the petitioner. So the same INEC he asked to come, will come and dump it and escape responsibility. Then you use insufficient evidence to verify and validate a clear electoral fraud. So let's restate again. This is not about whether it's PDP or APC or who ought to vote. It's the fact that as long as these kind of judgments are not reversed at the Court of Appeal and the Supreme Court, you are weaponizing the law against electoral justice. Abuja School feels that the judicial attitude towards electoral elections nullifies the purpose of electoral adjudication. You cannot prescribe standards to be used, and the regulator violates those standards, and you transfer an impossible burden on petitioners who will subpoena the regulator, and he says, I can't do this. They dump it, and he now says, because it was dumped. I think it's high time that the appellate courts have a clarity that electoral behavior is a cost-benefit, is guided by cost-benefit analysis. But as long as politicians will win in courts over these very strangulating technicalities and sometimes very false technicalities, fraudulent technicalities, as long as they win, they will have incentive to keep on manipulating the electoral system. But the moment the courts discover courage and clarity and begin to reverse this collusion with INEC officials, then the court will, two things will happen. First, INEC officials will have no more incentive, and nobody will pay you billions to go and use duplicate answer sheets if the court will nullify the election. That's basic incentive analysis. No governor or president or anybody will spend billions to rig elections if the courts will step up, vigilant and courageously invalidate elections. I think we should come to a point where the onus of proving this should lie on INEC. INEC, for example, if INEC had utilized the Electoral Act, INEC would not have announced results where the serial numbers were not, or results that their own verified IRF, which is the safest provision by the Act to create a credible filter for elections. So if you are announcing results and the results are totally different from what you post on your official, I mean, there's no serious person in the world who will hear that the electoral management body of a country has a electronic portal where it posts results, and the results on those portals are different from the ones they use to declare a winner. I mean, pure facie, that is fraud writ large. So the Abuja School wants to call on the appellate courts to put on a new lens and see these cases not from the arid and dry technicalities that they are creating up, but from the perspective of a jurisprudence that goes to protect the right of citizens. What we are seeing today is that INEC has usurped the right of citizens to elect their leaders by declaring fake results. An implication of that is that with the way electoral tribunals are enabling, is that electoral tribunals are now enabling INEC to continue to usurp the people's power and play rough through a crippling technicality that is wrongly applied. If the judiciary continues to allow the travesty that took place in Edo on September 21st, 2024 to stand, then we might as well all go home. 2027 and other elections will be farcical, impotent rituals used by the ruling class to give unilateral appointments of political office holders the imprimatur of democratic responsibility. So, in other words, we're going to now have a ritual, a holy ritual, and that's why people are saying, well, he can't defeat us all over the world. They're saying every governor, everybody said he can't defeat us. Even if we are misgoverning, even if the people don't want us, you can't defeat us. Why? Because we will win the election and the courts will say, go and bring all the voters in the whole polling units, and they give you 14 days to file everything, upload, get their signature, get their interview, and in that 14 days, you must produce two-thirds of all the voters in the whole polling units for that election. That's where we are trending. And that's why Abuja School, in condition of our mandate and our commitment to help raise alarm and offer solutions. We're having this conversation, again, not because we care about who is in power anywhere. We're having it because as a hub of intellectual scholars and policy professionals, our job is to, through our election observatory, to see problem, and through our deepening democracy series, to discuss on the way forward. I want to thank you for your time, and we have for questions, and my colleagues can chip in as they may feel relevant. Thank you so much.